Next, we're going to explore ways to handle high-pressure situations. On this topic, we will hear from Julien Hottinger, who is a senior mediator attached to the Peace and Human Rights Division within the Swiss Federal Department of Foreign Affairs. He has also worked as a member of the International Standing Hostage Negotiation Team. Hi, Julien. Protection advocates sometimes find themselves in high-pressure discussions and have to make critical and urgent decisions, which can have significant consequences on the protection environment and the population affected. Trust is obviously a critical factor to the success of the relationship when we're trying to establish one with our stakeholder and the outcome of the negotiation. So how can we build enough trust in negotiations, particularly when we're not so sure of the position of the interlocutor?
To build trust, it's always a complicated setup of mechanisms that you can't say there's just one rule to the thumb, and if you apply it, it should work. We have to work on trust differently according to the phases we find ourselves in, according to the knowledge we have of those parties are the people we're working with, and at the same time, with how we want to lay out the process with its objectives. I'd say honestly, when it comes to building trust at the initial phase, the most important is just to be clear as water, no ambiguity, no fooling around, and just being yourself as you are. And for the parties to be able to read you and to a certain extent get to understand you is the most important element. And then through that, you can start building trust. But careful, you'll never have full trust. You'll just have trust to be able to accomplish the first step, then build a bit more trust, accomplish the second step, and then probably get to a third, fourth, or fifth step, depending on how the process is going. But don't see this trust as full trust. And above all, what we call it usually in negotiations. This is pragmatic trust in a precise relation that's going through a process or is a process in itself.
Preparation is another critical component of effective advocacy and negotiations. In your experience, how should one prepare for a negotiation?
Well, I of course, have a formula I use that probably corresponds to myself. Reading, talking to experts, probably consulting some academics, and then listening, but attentively listening and actively listening to the parties. I don't expect the truth to come through the parties, as I don't expect it to come through other segments I've mentioned, but to a certain extent, it gives you a good idea of the general setting. And, it's not so much the learning about the problems that you have to deal with. It's more learning what is the attitude, what is the logic, and how do they perceive their own problems, and probably hint at some form of moving forward.
Julien, you've been involved in negotiating ceasefire agreements in Sudan, the negotiations between the government of Uganda and the Lord's Resistance Army, and that's only to name a couple. It'd be good to hear about some of the techniques you use when negotiating face-to-face.
Well, to start with, I'd say the face-to-face, when you meet for the first time, you stay modest and you listen. You don't come in saying, listen, I'm such and such person and I've been mediating or negotiating for 23 years. That is of no interest whatsoever. What you do is you come in, you show respect, you listen, you show empathy, not sympathy, but empathy. And through the empathy, they have the feeling that they're starting to get someone who's at least listening to them and understand them. Understand them, I said, don't mean sympathize with them. And it's through these exchanges where to a certain extent you show respect for the people, and at the same time they start showing respect for you if they weren't at the beginning, that you start building a relation in which you can say, we will be able to move gradually forward. It is time consuming. It's slow. And to a certain extent, it demands a lot of patience. But you've got no choice. If you can't get in those chunks of mutual understanding at the beginning, it's extremely hard to move forward on whatever you want to do following this first phase.
Yeah, so patience and respect are essential
and empathy.
In any negotiation.
I'd say patience, respect, and empathy are the three elements that I'd be looking at.
Could you please share with us some practical ways to reach conclusions when faced with challenging interlocutors or situations?
Well, it's even before you get to the conclusions that you have to be very attentive to those challenging interlocutors. You cannot leave them aside. Now, in a process, you might find yourself with some form of inclusivity that we call pragmatic inclusivity, but it still means you've got to deal with those who are either not in the process or to a certain extent not been integrated into our process yet. And it's extremely important as you're making progress within your process to also discuss with them, take their ideas and bring them into the process so that they feel they are contributing one way or the other. Usually, when we're confronted with challenging interlocutors, it's in respect with one aspect. When people talk of spoilers or difficult people, they're usually difficult in one sense or the other. It doesn't mean they're difficult in the totality, and you've got to understand where this difficulty is coming from. The other element is, as a negotiator or mediator, I don't focalize on what I'd say is the conclusion. It's, of course, I know we're going to get there, but I'm not focalizing on it. What I'm trying to do is bring the parties that are challenging each other's positions and interests to a situation that we call common ground, or if you prefer, ZOPA, zone of possible agreement, so that they can get into a situation where they start balancing around and changing ideas. And through those ideas, they themselves are going to reach a conclusion. And then the question is, the conclusion, is it viable? Is it pertinent? Does it contradict the rest of the agreement or other parts of the agreement? And to a certain extent, is it fair and even, as we would say? So it's more an issue of not giving the parties the impression that you're pushing for a conclusion, you want a conclusion, and we have to get it. No, it's more an issue of bringing them into a zone of comfort where they can gradually, they themselves, build that conclusion that they think would be the best in their case.
Sometimes in negotiations and discussions, in particular on protection, they can go around and around in circles with no concrete action or positive outcome. Do you have any tips on how to avoid a cycle of action and reaction within the process?
Yeah, I'd say it's in all processes we're confronted with this problem, and it's a common problem. And it's a question of breaking the cycle. You know, a mediator must never walk into a room with just one idea. You've got to have at least 3 ideas and saying, what I'd like to do is A, but if I can't do A, I will do B. And if I can't do B, we will do C. You break the action usually by turning the debate, or we switch the debate. Let me give you an example. We've got an issue we've got to cover around some political agreement of some sort, and we're discussing the powers of the legislative. What you don't do is you don't walk into the room and say, we're going to discuss this and I hope to have a result by tomorrow or the day after. You'll never get it. What we do is we work through a structure that we call the funnel. The first debate is about legislative systems across the world. We don't even cover the country we're supposed to be talking about. And we cover this aspect, and then we put it aside. We let the parties consult experts if they want to consult experts, go back and inform their constituencies, get the feedback from their constituencies, and they come back sometime later for a second debate. And the second debate, we start looking at more concrete models without mentioning the country we've been working on, and then put it aside so that they can consult again, talk to experts, and think things through. And it's only when they come back for the third time that we really say, well, now let's address the legislative in the country we're working on. And to a certain extent, we have empowered ourselves with enough knowledge and understanding within the room so as to know what we have to do, how we have to do it, and what could be the potential results. And this way, what you do is you don't give them a possibility of having the action, blocking things, holding things forever. There's a way of cutting through the substance so as it's timed out or framed out in a time that brings them the possibility of thinking it through each time before they get into this vicious circle.